Hi, everyone. This is Lynn Crawford from HOPE Dementia Support, and I hope you're having a wonderful new year. So I want to introduce to you a very special friend of HOPE, Joshua Pops, and I'll tell you a little bit about him. So about Joshua, he decided to become a lawyer after spending time as a teacher in Los Angeles. After his time teaching, he knew he wanted to continue to help others, but in a different way. He attended law school at Willamette University in Salem, Oregon. Being an elder law attorney continued that good feeling for him. He gets to do something he's passionate about and work hard while also knowing that he is helping others in the process. And in case you wonder about why elder law and estate planning, it always is nice to hear a story. So Joshua's story is, my grandmother lived to be 105 years old. She began to require nursing care in her 90s, and finally at 99 needed to be in a nursing home full time. Obviously, we were going to put her in the best nursing home we could find, and we were all blown away by just how much it would cost. It was especially tough knowing that my parents, now in their 70s and 80s, are on a fixed income themselves. While my parents were healthy, Grandma going into the nursing home brought up a lot of important questions. What will we do when Grandma runs out of money? If Grandma's nursing home turns out to have problems, what are our legal remedies? What if one of my parents needs care while Grandma is still alive? How will my parents be able to pass on as much of their assets as possible? What happens if one of them suddenly gets ill? After mentioning this to friends, I realized how many of us, young and old alike, worry about caring for ourselves and others. It may be a cliche to say we are living longer and costing more, but there is truth to that cliche. Helping my family out made me realize how much I can help others answer these questions using my legal skills and expertise. Now that I practice elder law, I continue to deal with these issues every day. In the fall of 2016, my parents moved to the Northwest to live with my wife and me. In the fall of 2018, my parents moved from our house to a senior living community. Eventually, my mother's care needs were too great. While Dad stayed in senior living, Mom had to be moved to an adult family home for dementia care. While Dad put on a brave face, I think the pain of separation was just too much. He passed away a little over 6 months after they were separated. I love spending each day with my parents, but I've learned a lot about the tough decisions many of my clients go through when their loved ones are getting old and it does not look exactly the way that we picture. So now you know why Joshua does what he does. When he is finished, we will have a time for questions, and as you're thinking of them, you can put them in the Q&A or you can put them in the chat, and we will be sure that the questions are answered. So Joshua, it's all yours.
Thank you, Lynn. My name is Joshua Pops. I am an estate planning and elder law attorney in Clark County, the greater Southwest Washington area. That background is why I do elder law. Not only is that what happened to me, but of course, I always like telling clients, HOPE was very important to me. My dad was a member of HOPE, and it was a great support for him while he was going through what he was going through with my mom. I think it shows a lot how much, HOPE can develop a community. That at my dad's memorial, there was a nice little HOPE contingent. That meant a lot. HOPE meant a lot to him. But enough about Dad. We'll get to that stuff as well, because a lot of that end of life stuff, care needs, those kind of things do apply in a estate planning context. And so what I'm trying to do today is kind of a greater picture of, if someone has Alzheimer's, if someone has dementia, and we want to do something before they, and I'm going to be use some cliched brusque terms, before they quote unquote lose it, what does that look like? What are we planning for? In terms of getting into the nitty gritty of long-term care Medicaid planning, that's a separate conversation. I've given presentations on that before. I'm always happy to do that again, but this is focusing more on the estate planning package. which again, we'll get into in a moment. So elder law, what is elder law, is the first question people ask me. It's an area of law that grew out of estate planning as people had greater care needs. So there is estate planning, estate administration, as we'd call it, which includes probate, trust and wills. I'll explain probate. Guardianships, helping manage someone's affairs if they can't, and that long-term care Medicaid planning. It grew out of estate planning because, as clients were getting older, as people lived longer and they had greater care needs, estate planning attorneys started running into greater issues than just estate planning. Occasionally, I will get someone who thinks elder law means you're just old. So, if you're 75 and you get arrested for a DUI, I'm not the lawyer you call. You call a different lawyer for that. When we're doing estate planning, one of the main things we're planning for is planning your estate, planning what to do with your stuff and who gets it and how we do all that when you pass away. The way we do that, the old-fashioned way, and the way a lot of people still do it in Washington, if you're drafting a will, you go through probate. People want to know what the heck that word means. My very first case as a lawyer, someone called saying they needed to probate dad's estate. And I said, that's great. Why don't we set up a phone call for next week? And then during that week, I had to look up what probate was and see if I could do it. Probate is a fancy word. It's just the legal process by which we manage someone's affairs when they pass away. So in the typical will situation, I, Joshua, draft my will, and my will nominates someone to handle my affairs. We call that person the executor or personal representative, the person who carries out the terms of the will. They pay all my debts. They make sure everything's taken care of. They sell my house. They gather everything in the bank account. They have an estate sale, and then they distribute everything that's left to my heirs. This is called probating the will, probating the estate. So let's say I have a will and I leave everything to my two heirs, Lynn and Julie. And my will says I leave everything to Lynn and Julie, 50-50, 2 shares. And I nominate Lynn to be the personal representative. I pass away. Lynn would take my will to the lawyer's office, who would take it down to court and would have the legal process by which we'd say we hereby, for lack of, there's more legal mumbo and jumbo involved than just the judge saying, I declare this will valid. But that's basically what they do. We now have the keys to unlock everything. Once my will's declared valid, Lynn can sell my home, Lynn can close out my bank account, Lynn can file my last taxes, she can pay any bills that are left, and after the bills are paid, she can split everything between her and Julie. Easily done. So then people say, well, what happens if I pass away and I don't have a will? Well, it depends. So if we're going through probate, we're probating your will, you drafted it, or we're probating your estate. That means we didn't have a will. We are going through a law in this situation known as the laws of intestate succession. So again, using Lynn and Julie as an example of, let's say my estate is, I have 2 daughters, Lynn and Julie. If I don't have a will, everything would go according to these laws to my 2 daughters, same as I'd want it to be. The thing is, it doesn't always follow a person's wishes. So if I like one of my daughters, but not the other, and I want Lynn to inherit everything, I wouldn't be able to do that unless I have a will. My will would have to say, I leave everything to Lynn, not Julie. If I want to leave anything to anyone else, I need a will. It's not the end of the world if we don't have a will. If the children get along, if we have an only child, if everything's pretty straightforward. So let's say there's 3 kids, instead of just 2, 3 kids, everyone gets along. The oldest sibling's generally been in charge. We don't have a will. Pretty straightforward. That older sibling would be the personal representative or executor. They'd be the executor of the estate, and they'd administer it the same way. Again, if you want to leave something to someone besides the usual kids, if you feel like there's going to be a situation where you want a specific person to be in charge or a specific person to have more, you have to have a will. And a lot of people, when I have that conversation about wills and probate, say, well, why is probate such a bad thing? And people have heard, oh, you have to avoid the horrors of probate. It's a terrible thing. It's the worst thing in the world. Don't do this to your family and loved ones. Those people, by and large, are Californians. Either they're Californians themselves, or they were told this by a relative or friend who lives in California. I can't tell you how many times someone comes into my office and says, I was talking with my sister and she says, I can't go through probate. And where does your sister live? California. Washington's probate process, meaning if you draft a will, how we plan for your estate, how we administer your estate with a will, probably the easiest in the country. The line I usually use is that the worst part about the probate process in Washington is writing a check to the lawyer. Everything after that is a piece of cake. The magical term we'd use and why Washington is so easy, it's a non-intervention state. Meaning if I have a will, I nominate Lynn to serve as personal representative, and my will says I want Lynn to serve. I don't want any court intervention. I don't want anyone to post a bond. It's the easiest in the country. Lynn doesn't have to check in with the court. She doesn't have to check in with the lawyer during the process to see if there's any, steps she's missing. Basically, we have a minimum amount of fuss. Everything's handled behind the scenes. If there is a problem, the legal system's there to help out. Otherwise, super quick and super easy, as long as everyone gets along. If everyone gets along, which is the big variable, then probate can be the easiest in the country. In a lot of states, Oregon, California, there's an automatic fee schedule, meaning the lawyer gets a percentage of the estate based on the size of it or based on a certain amount of things. Everyone gets along. Debts are easily taken care of. It doesn't take years. Realistically, if someone's coming into my office with a straightforward estate, including the court fees, including possibly transferring the house to somebody, we're looking at it can be done in 4 months. And you're looking at, again, give or take, so don't hold me to this, and we all know how inflation is, but talking nuts and bolts, how much does your average probate cost in my office? About $4,000. California, it can take forever. You can end up paying a lot more money. Oregon as well, you have a lot of hoops to jump through. You need court permission to do a lot of things. And in Oregon, you just don't. A lot of times people say to me, well, do I want a will or a trust? And we'll get to that more in a minute. But in Washington, more than any other state, the answer really is it's 6 of one, half dozen of the other. It depends on if you want to trust, what that looks like, if that's a good fit for you. And for some people it is, and for some people, they don't need to bother. So what is a trust? A trust is a way to pass property along without going to court. I'm not going to try to get too deep into the weeds of what a trust is, except to say that if you have property in the name of a trust, I live in Oregon, by the way, and because I live in Oregon, I have a trust. So my property, if something were to happen to me tomorrow, my son would inherit everything directly. He wouldn't go to court. He wouldn't probate my will or estate. There's a trust. It's the Pops Family Trust. And when I pass away, my son will take over as trustee and can then handle things the way he'd want. In Washington, when do people have a trust? Well, give or take, if you have over, the number here is 2 million, it's around 2.2 now. If you have more than $2.2 million net when you pass away, you're going to want to try and avoid estate taxes. You're going to want something more complicated than just a will. You're going to have a pretty high bill with the state of Washington for anything over $2.2 million if you don't plan ahead. You can also, of course, we've all heard the terms, trust fund kids. You can dictate how beneficiaries receive funds. If I have a will and it says everything goes to Lynn and Julie, everything goes to Lynn and Julie. There are no strings attached. At the end of probate, they each get a check, and it's don't spend it all in one place. A trust, those trust fund kids, those trusts dictate the terms under which people can receive money. A lot of people use it if if there's drug or alcohol problems, if there's problems with money, immaturity, things like that, you can attach whatever strings you want. Your only limit in dictating how people receive their funds is your imagination. My trust, for example, my son's 4. I don't know if he'll be responsible at 18 or not. So if something happened to me right now, a family friend manages money for him and he gets the check at 28. And at that point, hey, let's hope he doesn't spend it all in one place. I had one client, as an example of how creative you can get. His son was, I think, 12 or 13 when we drafted this. And so his situation was, well, just in case he passes away, his son would get a percentage at 18. Then he would get a bonus, for lack of a better term, for going to college. If he got under a 3.0 in college, he didn't get any extra money. And for every point between 3.0 and 4.0, every 0.1, 0.1, 0.2, he got a bonus every semester, for lack of a better term. You can get that creative. Another reason we definitely recommend a trust, we being me, the royal me, like, don't have a will, this is not a good situation, is if you have property in more than one state. Washington's easy laws, Washington's easy wills, easy estate planning, that works for Washington. If you have a house in Oregon, if you have a house in California, you have to go to court in those states. We don't want to do that, and we can avoid that with trust planning. And by the way, and that brings up a question people ask, does it matter where I am? No, it matters where your stuff is. If you own a house in Washington and you live on the moon, we're okay with Washington. If you live in Washington and you have a house in California, we'd worry about California. You do save those legal fees of probate. Again, not the end of the world compared to other states, but if you're drafting a trust 99 times out of 100, as long as everything was done right, as long as everyone gets along, someone calls me, there's a trust, and it's, I'm sorry to hear your loved one passed away. The good news is you don't need me. So there are, costs set up and, costs in setting up a trust in advance, but there's very little on the back end. You really don't necessarily need me as long as everyone gets along. And that is, by the way, and the $1 million question, no pun intended, of what causes estates to take forever and cost more than they should? People not getting along, period. People are going to fight. People are going to cause trouble. That's going to happen. So and people, come to me a lot. They come to me with what I call the giant, big, brown, fake embossed leather folder of doom. It says in fancy gold lettering, estate of Joshua Pops. It was drafted 30 years ago. It's that thick. I mean, you could hit somebody in the head with it. What should you do? 9 times out of 10, we're shredding the trust and we're making it either a very simple Washington trust or we're going with a simple will. This much estate planning, which a lot of people have from Oregon and California, you don't really need in Washington. And for lack of a better way to put it, it's kind of out of fashion in the legal profession to overwhelm people with paperwork. I'm usually taking this and turning it into what one of my clients called the little white folder of doom. So I refer to the estate plan as the little white folder of doom, or if you just have a will, just that little black folder of doom. That's all you need. You don't need a giant estate plan that goes on and on and on, and you've never looked at it, and the instruction pages, 10 pages, and you're afraid to even look at it. It's so confusing. Washington's a straightforward state. As long as we don't have to dig in because of heirs causing trouble, because of large assets in various places, pretty easy.
Joshua, let me ask you a
Yes.
question.
Please.
A comment from someone
Yes.
back when you said family trust.
Yeah.
So, and the question is, you said family trust, not revocable family trust?
Same thing. You can call, so when I say same thing, what I mean is there's more than one way to describe your standard revocable living trust. You could call it family trust, revocable living trust. They're all the same thing by a different name.
Thanks.
Yeah, so that is a good question. It's just, what names do lawyers use? I use family trust for some people. I use revocable living trust for others. It's kind of, more than anything, it's what you like the sound of, if I'm being honest. What if you have large debts when you pass away is a question people ask with a will or a trust. Your heirs will never have to pay your debts if you owe more than you own when you pass away. They never have to pay anything. If you owe more than you own, we're walking away. No one has to pay that bill. But with a will, and sometimes with a trust, but with a will especially, if someone owed money, you're going to have to pay that. You're going to have to pay that debt. You're going to have to handle that hospital bill, that credit card bill, that loan they owe money on in order to receive an estate. So don't think that if you have a large credit card bill that it magically disappears when you pass away. Your heirs are going to have to deal with it. And if it's a very large bill, there's no hiding in the sand. So theoretically, if you gave all your money away and all that was left was let's say a $50,000 bill, with a credit card, and you gave all your kids money the day before you passed away, that credit card company, should they choose to, could open up a probate just to get that $50,000 back from the heirs. I'm not saying it happens all the time, but that is a thing. And so people often talk about trusts with Medicaid planning, long-term care, Alzheimer's or dementia, paying for care planning. Do trusts help in Medicaid planning? Not as much as you think. I tell clients, when I see notes in my calendar and it says, so-and-so coming into my office, want to talk about a trust for Medicaid, I often have to end up telling the clients that's not necessarily a magic wand that you think it might be. We are not doing estate planning with a trust in that situation to magically make money disappear. We're doing that to avoid probate, which is a totally different situation. There are some exceptions, but I would say in general, for the sake of this holistic conversation, is trust planning a magic wand to avoid issues of spending assets to qualify for Medicaid? No, it is not. So is there ever a trust or a magic wand we could wave? There is one situation. That is for married couples. This is what is called a testamentary trust. Your will is your last will and testament, fancy legal language. And a testamentary trust is a trust that doesn't take effect unless and until you pass away. If I had a will and I'm married to Lynn and I'm well, I'm the well spouse, Lynn is in a facility with Alzheimer's or dementia, I would not want Lynn to inherit property if I were to pass away before her. If she inherits money, if I pass away and my will just says, I, Joshua, leave everything to Lynn, Lynn's obligated to receive it and obligated to spend it. We don't want that. The only magic wand I can truly wave to make assets magically disappear is a will with what is called a testamentary special needs trust. Those are magic words. If my spouse is in a facility, if Lynn's in a facility, I'm well, and I pass away suddenly, everything Lynn inherits from me is now protected, doesn't have to be spent on her care, and can be passed on to other beneficiaries. So I unfortunately have a situation where I tell the well spouse, I can wave a magic wand and it involves you passing away suddenly and tragically. Such is the nature of magic wands. When we're talking about estate planning, we're talking about passing along money. We're talking about people inheriting things. Also in that white binder of doom, as we put it, there's some other documents. When we're talking about an estate plan, what's estate planning? Well, that's a will or a trust that's passing along money, and it's other worst case scenario legal paperwork. Do you need a healthcare directive? What is a healthcare directive? A healthcare directive is also called a living will. I put nicer, clearer language in here, gentler, that it states if you'd like to receive artificial nutrition and hydration, if you're in a coma or clearly dying with little, medical hope of recovery. Putting it straight, that's the pull the plug document. It's a separate document, relatively straightforward in the state of Washington. You check a box. Do you want them to keep you going, or do you want to pull the plug? For anyone who has had to deal with it, when I was dealing with these terms, when my dad ended up going on hospice, he passed away from what I would call more than anything complications from surgery. He ended up having basically a perforated ulcer. So they had emergency surgery, seemed to be going well, and Dad was recovering until he wasn't. And after 3 or 4 days, it was clear something was wrong. He was on a trajectory of getting better, but the hole in, the ulcer hadn't fully closed, and then suddenly he started nosediving. And I left his hospital room. It was a Tuesday, and I called my wife and I said, I think I have to call the doctor. I think he's dying. And luckily, I was clear-headed enough that I, of course, I had the healthcare directive in advance. I talked with the doctor. We went over the language. We decided to remove artificial nutrition and hydration. And I asked her, Doctor, when would I not pull the plug in this situation? Why would someone not execute a healthcare directive in this situation? And without missing a beat, she said, oh, because you're in denial. For situations like that, when we're ready to put someone on hospice. Again, I use my own example. It wasn't easy, but that's what it was for. And that's what we ended up doing. That's why those documents exist. People have heard of mental health directives. Is that something you do? I generally advise keeping things simple or straightforward in a healthcare directive. The more specific situations you have, the more confusing it can be. If you trust someone to make that ultimate decision, trust them to make that decision. And there might be dissonance between what you want to have happen and what might be the best thing at that specific time for you. I like to tell clients, if you want to tell people how you feel about different situations and give someone written advice on what you hope would happen or what might happen in different medical situations, that's a great idea. Write it down, put it in the pocket of the binder of doom, make sure someone knows how you feel. But making it a formal legal document, I've seen, 8, 15-page mental health directives and more complicated advanced or healthcare directives. I believe in keeping it simple. The example I use is the example of dissonance of between what you'd like to have happen in certain situations and what's best for you is, we hopefully no one here has been in this situation, but I have clients who have, and I'll again use a generic grandma. Grandma said, whatever you do, don't ever put me in a home, quote unquote, in a home. Grandma's living on her own, can't live on her own, in terrible shape. But the grandkids are really in a bad situation because they know, grandma said, sometimes in writing, don't ever put me in a home. They're now having to deal with the fact that I try and tell them, grandma didn't necessarily mean don't ever put me in a home. What she meant was don't abandon me in a situation where I'm receiving substandard care that wouldn't allow me to live the most comfortable life possible. That's what grandma really meant to say. But she put some things in writing, set them in stone that really caused more than anything, caused a lot of emotional damage to the clients. It was hard for them to understand that when grandma checked a box that said, don't put me in a home, that might not have been the best decision on grandma's part. Many clients, and this comes up a lot, especially with Alzheimer's and dementia, many clients want them to have a directive that allows them to pass in peace. Oregon and Washington are both the same. They mandate spoon feeding. What that means is if I have Alzheimer's or dementia and I have something that says I do not want spoon feeding, if my Alzheimer's and dementia is such that I can no longer recognize that, someone is obligated to attempt to spoon feed me. And if I eat it, I eat it, even though that wasn't my wishes. They can't withhold food. That's a difficult one that comes up a lot because people talk about, and they hear, healthcare directives, a good time to talk about this. Assisted suicide laws, they apply in very narrow situations. Alzheimer's and dementia doesn't work for that. You have to have a very clearly terminal diagnosis. It has to be short-term and you have to be cognizant. And because, as we all know, Alzheimer's and dementia, it could be tomorrow or it could be 10 years from now. Death with dignity laws, assisted suicide laws don't work for Alzheimer's and dementia. The last important part of that binder of doom, for Alzheimer's and dementia, as important as anything, do I need a power of attorney? Yes, get a power of attorney. If you got a cheap power of attorney, and I'm not saying this derisively, but if you got a power of attorney off the internet and signed it at the bank 10 years ago, or if you drafted your power of attorney 35 years ago, get a new one. If you've never drafted a power of attorney, get one. If someone has Alzheimer's and dementia or any situation and you don't have a power of attorney, if they're no longer able to manage your affairs without a power of attorney, you can't take over. You can't write checks. You can't make doctor appointments. You can't file their taxes. You can't move their mail. You can't do anything. A power of attorney easily takes care of all that. Most of my powers of attorney, the vast majority, are combination medical and financial powers of attorney effective immediately. The reason why I recommend that, just so everyone knows, again, I give the example. Mom's still alive. Mom has Alzheimer's. Mom is incapacitated, clearly incapacitated. If I had a power of attorney that said effective upon incapacity, it'd be easy to get a doctor's note to make that power of attorney take effect. Dad passed away at 88. Was Dad incapacitated? No, I wouldn't call Dad incapacitated. Did he need my help balancing his checkbook and making doctor appointments and handling his taxes and refilling his prescriptions and uploading a form to get a reimbursement for his health insurance? Yes, he needed help with those things. As people get older, Alzheimer's and dementia or not, they can end up in the cracks between capacity and incapacity. If you have a power of attorney that says effective upon incapacity, sometimes you might want to take over earlier than that. My parents' powers of attorney were effective immediately. That didn't mean I had to take over right away. My own power of attorney is effective immediately. That just means whenever my wife needs to step in, she can step in. The other reason I'm not a big fan of powers of attorney effective upon incapacity, a lot of times if we need a power of attorney, it's because something terrible has happened and we need to make decisions right away. Time is of the absolute essence there. If I get trampled by a turtle or if a piano falls on me and we need to make a decision right away when I'm in the hospital, what are we going to do now? What's going to happen? We want that power of attorney to be effective immediately. We don't want to waste 1 second waiting to get a letter of incapacity so that we can start taking over. What happens if you don't have a power of attorney? Well, then we're looking at a guardianship or conservatorship. I'm not going to try and scare you and say they're impossible. They involve paperwork. They're an annoyance. It's not the end of the world. I'll walk you through it. But a power of attorney is a million times easier. One of the problems we often have with a power of attorney is the capacity to execute it. Alzheimer's and dementia, we all know how that is. Sometimes sometimes people have, as we all use that cliche of, better days than others. If someone is able to recognize the contractual obligation giving someone else the right to manage their affairs, we can have a power of attorney. I've had situations where clients don't know I'm a lawyer, think I'm a family member. We mention a power of attorney and they ask what they're doing the next sentence. Those aren't situations where a power of attorney is appropriate. I'm just putting it to you straight. You're not really doing yourself any good. Because more likely than not, I can give you the example of a recent situation where client had powers of attorney, got them online, had them notarized, but his mother didn't really have capacity. So as soon as we tried to use that power of attorney at the bank or at the doctor's office, they basically said, "Oh, no, we know that woman. We're not taking this one." Those are the kind of situations you end up with. The other main document, I didn't list it in this frequently asked questions, but it does come up and it's part of the estate plan, is what in Washington is known as the Disposition of Remains Preferences, which is a very nice, gentle legal way of saying, and I put this as bluntly as possible so we know, what do you want done with your corpse? Or more importantly, if you don't know what you want, nominating someone to make those decisions. I would say in general, I've noticed that the idea of a large funeral at the funeral home or at church with a picture of you when you were young and a black wreath and the organ and the open casket, that's relatively out of style. Most people these days, their wishes are cremate me and surprise me. For that situation, the Disposition of Remains Preference I draft doesn't say cremate me and surprise me. It has the legal equivalent of cremate me and surprise me. But the idea is if you want to be cremated or if you want to be buried, make sure that's in writing, make sure it's the valid form. Again, not that I'm trying to scare anyone, but I've seen it a couple times of a funeral home where one child was the responsible one. One was both these specific situations. The other child was living on the streets, for lack of a better term, didn't have a fixed address, hard to pin down. But because the funeral home didn't want to worry about liability with this other child who was out on the streets that we couldn't reach, the funeral home basically said, well, we'll let you get a court order giving us permission to cremate. But until then, we were keeping the parent on ice, literally waiting to get a court order saying, yes, it's okay to cremate. I'm sure there'll be a million questions. I know, the Q&A is what people like. So I tried to keep the brief estate planning part of it short so that people can ask questions. People can tell me what came up, but that's what the estate plan looks like. It's a will or a trust for passing along your situation when you pass away, passing along property. If your spouse has Alzheimer's and dementia, we're drafting your will to have a special needs trust. We're drafting a power of attorney for everybody. We're drafting a healthcare directive for everybody. And we're drafting a disposition of remains preferences form. It's pretty straightforward. I personally, as an attorney, don't have giant intake packets that thick. When my parents were down in California, I found them a great attorney, nationally recognized, who lived catty corner from their condo. And his intake form was that thick. And it took my parents forever to get into his office to draft their estate plan. I told them, you two are going to die before you finish that giant intake form. Just go into his office and tell him you got a condo and 3 bank accounts. That's it. Boom, get in there. But they were so intimidated filling this out, making sure they had everything right. It's more straightforward than you think. Sure, some assets require us to have paint a bigger picture and require some difficulty. But in terms of what your average run-of-the-mill estate plan looks like, that's pretty much it for Washington. The healthcare directive, the power of attorney, a will with a special needs trust, again, those are things we want to have in place. If someone has an early diagnosis of Alzheimer's and dementia, if someone is still, again, using this brusque term, if someone is still with it, but we have a diagnosis and we're starting to notice some gaps, we want to make sure we have things drafted in place while they're still able to sign. We want to make sure if someone has an idea of how they want to inherit property, that it's in writing while they still can sign and dictate those things. Again, we're not doing this for magic wand Medicaid planning. Medicaid planning is a whole other thing other than that magic wand of wills with special needs trusts. I see a few chats, I see a few Q&As, and from having given this presentations for HOPE before, I know that questions always beget other questions and things extend. So I thought this might be a good time for us to open up to the chat and the Q&A.
Perfect.
And Lynn, you want to handle that, correct?
Sure.
Okay.
So does the Testamentary Trust preserve money for kids as well as spouses?
Yes, that's the good thing. So if and again, we're using you as an example, Lynn, if you're in a facility and I draft my will and it says I leave everything to Lynn's special needs trust, when I pass away, everything's in your trust. The kids can use the money for you if you need anything. If not, when you pass away, everything goes to them. The state does not have to be repaid. So they don't inherit everything right away, but they do inherit what's left, and the state does not get a claim on anything. That's another part of that magic wand.
How do I go about getting a doctor's letter to activate a power of attorney? My dad has vascular dementia.
Mm-hmm. And that's, again, why I'm not a big fan of powers of attorney effective upon incapacity. You're making an appointment with a doctor and getting them to write it. The letter can be as simple as Dr. Joshua Pops have, examined Lynn Crawford. I declare her incapacitated. That's all it needs to say. A couple of the problems I occasionally run into are a doctor's note that goes on and on and on and doesn't actually state incapacitated or doesn't summarize things. And they've basically written a very fancy, impressive letter that doesn't tell me what it's supposed to tell me. Or occasionally a doctor will say, oh, that's a legal matter. I'm sorry, I don't do legal things. It's kind of like, well, okay, then we need to find a new doctor. I've had it, and it's only come up a few times, but boy, is it frustrating when we have the general practitioner, for Lynn, we take her into the doctor to get a letter of incapacity, and the doctor says, I'm sorry, I can't make that determination. Honestly, in that situation, we're finding a new doctor or finding some, medical professional who can examine, your loved one in that situation and write that letter saying, I declare them incapacitated. Simple as that.
How does one determine legal capacity to make decisions for an aging parent with slipping mental capacity in order to protect them from inappropriate financial decisions?
That is so slipping capacity, even if you have a power of attorney, that is a possible bad news situation. And let me explain why. A power of attorney supplements rights. It doesn't take away rights. If you're on, a loved one, and again, using the generic grandma, if you're on grandma's bank account or your grandma's attorney in fact or agent, you have her power of attorney. You can help manage grandma's affairs. You can write checks. You can balance her bank account. You can handle everything. That doesn't take away grandma's right. If grandma's giving money away to people she shouldn't be, if she's being taken advantage of by a scammer or an unscrupulous neighbor, and grandma's not remembering it, sometimes the only way to stop the bleeding is to file a guardianship. If you file a guardianship and grandma is declared to be a person who needs a guardian by the court, who, if you file it and the court appoints you guardian, now grandma does not manage her own money. She does not have access to the bank account. She can't write a check. She can't give money away. She no longer manages her own affairs. As long as she has that, as long as she has access though, even with a power of attorney, or if you just on grandma's bank account, then you can't stop that bleeding. And that's a difficult one. That comes up a lot, unfortunately.
So the one document you didn't mention is the post. Is the post needed?
Yes, I should have mentioned that separate from a healthcare directive. The reason why it wasn't on here is because a POST form, Physician's Order for Life-Sustaining Treatment, POST, P-O-L-S-T, is done with a doctor. A healthcare directive and a POST are for two different situations. So let me give you an example. One's short-term, one's long-term. The POST form, it's a bright pink or bright green form. I tell clients, if you have your POST form up on the fridge, congratulations, that means you're old. The POST form is what we used to call DNRs, do not resuscitates. That lets emergency personnel know what decisions, what healthcare measures you want taken in that situation. The reason why if you have that POST form up on the fridge, you're old, is because that means you've had a stroke or you've broken a hip and they find you in a puddle on the floor. That tells the paramedics, the medical personnel in that moment what you want done. The healthcare directive, the living will, is for that longer term hospital situation. You're in the hospital, you've been there a while, you're not getting better. What are we going to do now? Healthcare directive is done with a lawyer, POST form is done with a doctor. Similar, but for different situations. Again, if it's in a drawer, if it's in a safe, you're not old. If the POST form is up on the fridge, that means you're elderly. That's where I draw the line.
How often do you recommend estate planning documents be reviewed?
So, you never know, as what I would put it, eyeballing it every few years. For instance, the powers of attorney were the same for forever and ever. And then in January 2017, Washington had new laws. Other than that, things are relatively stable, especially with a will. If you drafted a will 45 years ago, I've probated some old wills, and everything goes to the kids, you don't need to update that will in most situations. When people choose to update their estate plans, being honest, most people do an estate, go to see a lawyer like me twice in their life. Once when the kids are little, and once when the kids are grown up. I have right now, for my wife, our estate planning documents have a family friend who would be the backup to manage our affairs, would be our power of attorney, would manage our healthcare directive, and would also be the guardian for our son. Realistically, 25, 30 years from now, knock on wood, my son's got a good head on his shoulder, can manage his affairs. I'm going to redo everything. I'm going to make him the backup. I'm going to make him the trustee. I'm going to make him the power of attorney, and I'll leave it there. My parents drafted, I remember because I was going through it, their first estate planning documents in 1981 when I was 3. And then they redid it when I was in my late 30s, now that I, got them to a lawyer. And that was, the logical time. They did it when their son was 3 and did it when he was 35. That's typical.
So what does a simple trust cost?
Well, again, it's always, you don't want to ballpark it. Your average simple estate plan, the random number, I will tell you, for instance, I spoke with a client earlier this morning. They owned a house. We needed a trust. We needed powers of attorney. And they were looking at, for a couple, and this is a random number, $2,525.35. Why a random number? Because we are transferring things into a trust. That includes recording a deed with the county, and the county charges $225.35. Again, that being said, every situation is different. So, it's not like I'm putting out coupons like that or anything like that, but that's what your average revocable trust costs.
If I have a trust
Mhm.
and have given our children different percentages,
Mhm.
can I change this on my own without going to an attorney?
Theoretically, you could. I would say it'd be worth it just to come in and see me to make sure we're not screwing anything up. Make sure you're changing the right part. I've got a notary stamp. It'd be easy. Again, theoretically, you could on your own. You can always change it. I have one client who changes the percentages on his trust a lot. I have a long-term relationship with him. I'm just changing the number and signing the same piece of paper and notarizing it. And when he changes those numbers, he shows up in my office and he drops off a case of beer. Easily done. So theoretically, for established clients, things can be as cheap as bring me a case of beer and let me know what time you're going to be here.
So what happens if I don't have the original will, just a copy?
Unfortunately, the will is the one document you need the original will. And again, using the example, if I have two kids and I want to disinherit one, my will that I drafted 30 years ago says I have two kids, Lynn and Julie, and I leave everything to Lynn. I omit Julie. A copy's not good enough. You need the original. If you drafted it recently, if you know who the witnesses were, you can verify that that's a copy. But if you have a copy, not an original, it's not the same thing. You might want to contact the lawyer you drafted it with. Some old-fashioned lawyers, this was an older practice. Lawyers would have giant will repositories. They'd hold on to the originals, and clients would contact the lawyer when the loved one passed away. Most lawyers don't do that anymore. It's just, in the digital age, it just doesn't make sense. So for instance, I don't hold on to originals. Realistically, if you have a copy and it gives someone a larger percentage or leaves somebody out, you might want to look for the original or redo it.
So our documents are all done, but it's been over 10 years. Dad has passed and mom has dementia. What's a ballpark figure for review of documents?
Depends on where you went and what you got. I hate quoting just because it could be simple. I've seen needlessly complex things. It all depends on what you had lined up before. There's a reason why people don't like seeing, lawyers and mechanics. It's because until we get under the hood, we can't necessarily say what's wrong. I know that's such a cheesy cliche answer, but it's true. That's why a lawyer's website never says how much they charge. It's like if anyone's planned for a wedding, you'll never get a straight answer how much it costs.
My mother with dementia will be inheriting life insurance money. Any advice on using it to pay for care? Do creditors have the ability to get at it while she's still alive?
Not while someone is still alive. But when we say creditors, in other words, if you owe money, sure, people can try and come after you. If someone inherits life insurance, a small amount, the big problem we usually run into with someone with Alzheimer's and dementia is sometimes they're already on Medicaid and we don't want them to inherit money and now we're stuck. For life insurance, it depends on how much it is. If you have bills to pay off, that sort of thing, that's fine. Usually if someone has Alzheimer's and they're in a facility and they're inheriting money, we're not worried about paying bills because we don't care about their credit rating. If I found out that my mom, somehow won $10,000 in some life insurance policy I didn't know about, I would not be in a rush to pay any outstanding debts. I'd use that money to pay for her care.
When it's time, do you provide support for executors of an estate? It seems like there's a lot of details to work through.
There's a lot of details to work through. It's simpler than people think. I think once you really get started, and what ends up causing, but just so everyone knows, what ends up causing the most trouble for executives or personal representatives isn't the legal side of things. It's, again, using generic grandma is, we have grandma's will, but her place is a mess. We have no idea what she had. We have to go through everything, and it takes forever to sort out all of grandma's estate. I give the example, I have, me, again, being a lawyer, I'm neurotic. I have time to think about these things. My white binder of doom, on the inside pocket, there's a 3-page letter to my wife. And it says, Tootsie, if I've passed away, here's the name of the person at the bank you call. Here's the name of the life insurance agent. Here's the name of the financial advisor. Here's the name of the person at the funeral home, down to those things. Here's the bank account numbers. My grandma, every few years, would sit down at her typewriter on her, First National Bank of Larchmont stationery, and she'd type up a list of what she had and who she worked with, and she'd mail a copy to my mom and mail a copy to my uncle. Every 3 or 4 years, she'd sit down and do that. If you're taking those steps ahead of time, you're not leaving your executor with much of a bad situation. Sometimes it just ends up with more hand holding than we need to. And, that's part of the gig, talking people through. But yes, the question is, do I have to hold hands, while we're being an executor? Of course. I'm always getting an email of this or that, and we're answering and making sure everything's okay. That's a long story short. Let people know in advance what you have so that you're not leaving the heir in a situation where they feel like they're drowning.
So in the example given, the
Mhm.
grandmother giving money to neighbors or being scammed,
Yeah.
what is the cost for a family member currently designated as the durable power of attorney for finance and healthcare to then pursue guardianship in Washington?
The big question is, will grandma accept a guardianship? In the same way that what causes things to cost a fortune and take forever in an estate are people fighting. The problem is, we see this a lot in Alzheimer's and dementia. As I often say, the last thing to go is sometimes the ability to say, I'm fine, leave me alone, I don't need help. If we file a guardianship or conservatorship for someone who clearly needs help and they say, I'm fine, leave me alone, I don't need your help, they have the right to do so. And most importantly, they have the right to request their own attorney. In those situations, guardianships can get ugly. And so the question is, how much does it, how long does a guardianship take? How much does it cost? Depends how much grandma's going along for it.
If your parent dies penniless and has a will, does probate still cost?
No, because they're penniless and we're not inheriting anything, we're usually, if I have a situation where someone comes to me and yes, grandma had a will, but grandma had, $200 in the bank and she has debts of 20 grand, we're just writing a letter to each creditor saying, hey, we know you received notice grandma passed away. She had no money. We're not opening probate. Don't bother. No.
So that's a good question that people ask a lot, is that, so grandma died, she owes $20,000.
Yeah.
Can the creditors come after the family?
Not if grandma had nothing. No. You're never responsible for someone else's, debts if their debts exceed their assets. If grandma had $200 in the bank and she owed 20 grand, you are not responsible for a penny.
So if grandma had $200 in the bank and owned a house, are you responsible for selling that house so that you can pay her debts?
Yes. In that situation, it takes money to make money.
Okay.
If grandma's estate is solvent, if grandma's worth more than she owed, we're filing probate, we're paying creditors, and then we're splitting whatever's left.
So if I heard you correctly, when there's a trust, you don't probate it.
No.
If everyone agrees with the trust, the executor can just proceed with the estate. Is that correct?
Yes. When a client comes to me and, everyone gets along, everything was in the trust, I don't think I need your help, the answer is you don't. Show your work, make sure everyone's on board, make sure everyone agrees on the numbers, but you don't need to go through a lawyer if everyone agrees.
If a person does his or her own will, you have witnesses sign it rather than have an attorney draft it, can it cause more contestability issues?
If it's valid, even if it's handwritten, not necessarily, no. And the problem with contestability is I have clients come to me and say, well, I drafted a will myself, but I want a lawyer to draft it so no one can challenge it. Well, it's not that no one can challenge it. People always have the right to make everyone's lives miserable and challenge everything. It's just a matter of, even if you write your will by hand and have witnesses, It could still be challenged. It would just be a matter of they wouldn't be winning the challenge. No, you can write your own will. You do need, however, to have witnesses, and you have to have the right, paperwork. Washington doesn't have what are known as holographic wills, meaning just a piece of paper that you scribble everything on. That's valid in some states, not valid in Washington.
So isn't there probate always for a will?
Only if we have things to distribute. You are not obligated to probate a will if there's nothing to distribute. If I have $200 in the bank and my will leaves everything to 10 different people, we're not going to probate the estate over that $200. It doesn't make sense. We are never obligated to probate anything.
I might have missed it. Do you need a will if you have a family trust?
No. If we're drafting a family trust, we often draft what are called pour-over wills. My will says I leave everything to the Pops family trust. As I put it, that's the legal equivalent of a reverse jinx. But no, you can get by with a trust and not a will.
There's a comment that they love the white folder of doom.
I can't take credit for that. One of my clients referred to something as and now we've got the white folder, binder of doom. And I said, oh, that's great. I got to use that.
Is there such a thing as an irrevocable family trust?
Long story short, yes. I would say that's beyond, your average Tuesday evening. We're talking about Alzheimer's and dementia, but yes, there are trusts that are irrevocable. That being said, I've revoked irrevocable trusts. One of the first days of law school, my professor said ignorance is never an excuse except for when it is. I always say an irrevocable trust means the trust can never be revoked except for when it can. How's that for a straight ahead answer?
Yeah, that's as clear as mud.
Yeah, exactly. Happy to help.
If you set up a trust, how often, if ever, does it need to be updated? And the same for the will. And I think you answered this at one point.
Yeah.
But can you answer it again?
Trusts and wills, not terribly frequently. If you have an Alzheimer's dementia diagnosis or you've recently retired, it makes sense to go see a lawyer and verify everything's okay. But it's not like you have to go see somebody every 3 years or 5 years or everything like that. There's no such thing as a trust so old that it doesn't, that it expires, or a will so old that it's no longer good anymore. If I have someone who's 100 years old and they drafted the will 80 years ago, that will could still be good.
What would you recommend that everyone get done?
Power of attorney, 100%. Everybody. The day you turn 18, you should have a power of attorney. So that if you get trampled by turtles or a piano falls on you, nobody has to file for a guardianship.
So if it isn't necessary for everyone to have a will or a trust, when should it be done?
Usually the only time I'm saying we don't need a will or a trust is when I'll give you another example. I was dealing with a client. We had to file a guardianship for both of his parents. And he said, my parents don't have a will. What am I going to do? And I told him, you're an only child. The laws in Washington are so simple and straightforward. You're going to inherit everything anyway. We don't need a will. I have a lot of, I'll use this term as a term of endearment because my mother is one, little old lady clients who have 1 or 2 kids. Usually it's a little old lady with 1 kid. Oftentimes the son or daughter is sitting there with this little old lady. And they say, we have a very limited budget. What would you recommend we go with? Power of attorney, not a will. If you have an only child or a situation where there's going to be nothing to distribute, you don't need a will or a trust. Most people do. Again, only children is a unique scenario in the state of Washington.
And I believe you addressed this, but about the original paperwork, where should it be filed?
I scan everything into my computer. I do not hold on to originals. I advise clients to keep things in a safe but accessible location. This was recently, there was a back and forth, and the financial advisor in the Oregonian, they have a daily column, Liz Weston, I think. There was an article about where you should keep your estate planning documents. I do not recommend safety deposit boxes. Keep your originals in a safe but accessible location, a gun safe, a fireproof safe, not a safe deposit box.
What if the daughter is named on a bank account or other accounts like credit cards of her mom's?
Mhm.
Mom dies and there is significant debt. Could the daughter owe any of the debt?
Depending on whether you're a co-signer of the account, yes. In a usual situation, I say never contact a credit card company first, let them contact you. But if you have a credit card account, and a lot of times, like for example, my parents had a credit card. I was not quote unquote on the account. I had a card so I could use it. I was a listed user, but it was not my credit card account. There was no credit check for me. It was just an extra card. You could get a certain number of cards with names. So it's important to find out if you're on somebody's credit card, whether you co-signed or whether you're an authorized user. Those are the kind of generic terms. Are you a co-signer or an authorized user? The one situation we get into, by the way, that can cause trouble with bank accounts is if you're a daughter on mom's bank account, the time you can get into trouble is if most of mom's money is in the bank account, there's a will that divides everything among other people and people don't get along. Now you're in for a fight.
There's a comment that says, thank you for helping us to understand all of this better. You are very
understand some of it. I understand, lawyers aren't great for making things simple and easy.
Is a power of attorney the same as a personal representative?
No, good question. A personal representative or executor is a person who manages an estate after a person has passed away. A power of attorney, my will designates my wife to serve as personal representative. My power of attorney designates my wife to serve as attorney in fact. One is when I'm alive, one's after I've passed away. And in fact, this does come up sometimes. A power of attorney automatically ends the moment somebody passes away. So I'll occasionally get this. I don't do disputed estates anymore, but occasionally son would be listed as the attorney in fact on the power of attorney. Daughter would be nominated as the personal representative, and the son would tell the sister, mom made me power of attorney. Now that she's dead, I'm in charge. And the answer is no, actually, that's the opposite. You're totally not in charge.
Not sure I knew that.
Yeah, now you know, power of attorney, the moment you pass away, that's it.
Wow.
So if you're managing someone's affairs with a power of attorney, and this happens a lot and it causes frustration, folks, this is just the way the system works. If you are nominated as power of attorney and you were managing mom's credit card and you were managing her bank account and you could access her financial records, the moment mom passes away, they're going to lock you out and you're going to have to use the trust or the will to then take care of those things. People get very frustrated when they say, well, I was mom's, power of attorney and I was at the bank for years and then mom passes away and I show up and they said I couldn't do anything.
So if you are an executor of a will, is that the same as being a personal representative?
Yes. Same thing.
Okay. If I have a power of attorney and want to have mom's documents reviewed, would I need to bring her in to meet with you, or can I do this for her?
No, you can't do someone's documents for them. And one of the things we have to be careful with is let's be honest, there's a fine line between I help mom out with everything. I'm here to help explain what mom would like. And hey, mom wanted me to inherit a bigger share of the estate. Isn't that right, mom? So we can't redo someone's estate planning documents without them. I tell clients, if someone calls me up and they say, grandma said they wanted me to inherit everything. No, hold on, stop there. I'm not talking to you. Drop your grandma off, wait in the waiting room, and let me talk to grandma.
So describe a conservatorship.
A guardianship or conservatorship is a way we have the legal right to manage someone's affairs who's unable to do so. A guardianship and conservatorship, putting it loosely, they're the same thing. Guardianship takes care of the personal stuff, conservatorship takes care of money.
Okay.
Yeah.
You mentioned Washington made changes to the power of attorney.
Mhm.
Our dad's power of attorney was done in 2008. Now he has dementia. What do you suggest based on the changes in 2017?
If dad has dementia or Alzheimer's such that he's no longer capable of understanding what he's signing, we're stuck with the document from 2008. There are worse things. I'd rather have a power of attorney from 2008 than no power of attorney. But if someone still has capacity and they have an older power of attorney and it's one of those, they have money burning a hole in their pocket, they're dying to see an estate planning attorney, what's the number one thing I need to change from 2008? Power of attorney.
And then here's a comment in caps, says review, not redo.
Yes, I'm often reviewing things and being honest. What does it mean review, not redo? Well, those are two different things. A lot of times I look at someone's stuff and I tell them, other than a power of attorney, again, because that's the one thing, you don't need me. I'm not going to redo anything for the sake of redoing it. I had one client, for instance, who, again, this was a long-term client. I drafted their will many years ago. Their daughter had been divorced and remarried. They wanted to include their daughter's new married name. That was we know who your daughter is. You don't need to update this, but if you really care a lot and want to have her new name in it, let me know when you can be in the office and bring a case of beer.
If you had one thing that you would want people to know related to completing an estate plan, what would it be?
As you might have noticed, I'm going to say it again, more than anything else, power of attorney, power of attorney, power of attorney. What really concerns me is when I have older folks coming in who say, oh, I don't want all these bells and whistles, just the will, please. And I try very hard in those situations without making them, because they're I don't want to be sold on anything, without trying to quote unquote sell them, trying to explain to them, you really, really should do a power of attorney as well. More than anything, people think about an estate plan as just the will or who's going to inherit everything. But what ends up with, that healthcare directive and power of attorney, those quote unquote other documents can sometimes end up being just as important.
Awesome. And we have a comment that says, thank you very much. We appreciate all of the information.
Lynn, I will tell Lynn, I'm always happy to help Hope. As I said, there were people at my dad's memorial from his Hope group. I'm always happy to help Hope.
Let's see. You mentioned a testamentary.
Mm-hmm.
I was taking notes, but got lost on that one. Maybe it's associated with a living will.
So it's with your last will. A testamentary trust is something that doesn't take effect until you pass away. Your will, if you've seen a will, it has the fancy lettering on top. It says last will and testament. A testamentary trust does not take effect until you pass away. So again, using the example of if I'm married to Lynn, Lynn has Alzheimer's, and I draft my will with a testamentary special needs trust, we don't deal with that trust until I die. The moment I die, now that trust is created. But a testamentary trust is waiting for someone to die before it exists.
That's the first time I ever thought about not knowing what will and testament meant.
What does the testament part mean?
Yeah.
I don't know. I don't know why we started calling them last will and testament. That's what we call it.
Huh.
A history of legal mumbo jumbo is above my pay grade.
So, question, does a durable general power of attorney cover all aspects, including the healthcare directive and financial things?
So usually it does. but you'd have to look at the language. Some people have a durable general power of attorney that ends up only being for one or the other. So it's important to look at what you got and look at what it says. And if it's only talking about medical stuff or it's only talking about financial stuff, it can only do what it says.
Well, I can tell you as an old hospital nurse, we ran into that all the time. That people thought that they had the power of attorney for healthcare.
Right.
And in fact, what they had was the financial, or vice versa.
Yeah, I bet. I'm sure, Lynn, you had that all the time, where they said, I can make medical decisions. And you look through and it's talking about bank accounts and sales and transactions and redirecting mail, and you don't have both.
Exactly.
Most of my powers of attorney, the vast majority, 99 out of 100, we combine medical and financial.
Does my power of attorney need to live in the state of Washington?
No. I tell clients it matters where you are. I have clients who serve as personal representative of an estate or power of attorney for a loved one who I haven't met in person. You know, they're in Texas or they're in North Carolina or they're in Colorado and grandma's here. It doesn't matter where they are. They could be on the moon. If you're here, it's okay.
What kind of beer do you like?
Cheap
Laugh
beer.
out loud.
Cheap beer.
Cheap beer.
I always need to make a point. Occasionally when I mention that, a client will drop off, a case of IPAs or, 12 pack of IPAs, and I just give it to my wife. I ended up having to write a letter to a life insurance company to make clear that we didn't need to write a will. And I'm staring at a 24 pack of Coors that I brought downstairs this very afternoon from a client.
Our financial institutions require a letter from the doctor that states, my dear one is unable to manage her money, but won't provide the exact language. And the doctor prefers to sign a form and not compose a letter from scratch.
What a mess.
This seems to be a common malady. Why isn't there a standard form?
I wish there was a better way to put it than I wish I knew why financial institutions want to make people's lives miserable, but they do. Because every company has a different form. And Washington does not have a uniform. The Uniform Power of Attorney Act, which is the fancy term for power of attorney laws in Washington, does not have a form regarding incapacity. And one of the things I run into a lot that drives me nuts is the bank or the hospital or the credit card company or the life insurance or whoever, you have a power of attorney and they say, I'm sorry, but we need our own in-house form. This isn't any good. Or I'm sorry, I know this power of attorney said it's effective immediately, but we need a letter they're incapacitated. That's when I don't do adversarial litigation. If people are fighting, I don't handle it. So the only way, I can still get that excitement of writing nasty letters is usually nasty letters to banks. Again, I very rarely get to write nasty letters. I might get to write a nasty letter to Chase Bank next week, and I can't wait. Those are the only nasty letters I get to write.
When I hear about all of these issues, I have to say that I never ran into one single thing like that when my husband was ill and when he died. And I don't understand. Did we do everything right, or was our banks just...
Listen, I'd rather be lucky than good any day of the week.
Well, that must have been it.
Just walk casual and try not to make too much. Try not to make too much eye contact, but try not to make it look like you're avoiding eye contact. I tell clients all the time, they say, like, should I ask the bank this or that or the credit card company? No, do not wait for them to ask you in that situation. Congratulations, everything went fine.
So if mom's got dementia and mental capacity is questionable, and as the power of attorney, I can't have her documents reviewed, am I best off to just do nothing? Well, I'm not sure if she'd understand what was going on and might get scared and upset.
I mean, with Alzheimer's and dementia, that's always a difficult call of, if you think it would do more harm than good to bring them into a lawyer's office, don't bring them in, and we'll deal with the documents we have as best we can. Those are always, the difficult calls are those, what I would call, quote unquote, judgment calls. on powers of attorney. Again, because we all know there's good days and bad days. And sometimes when I meet with a client after we sign a power of attorney, or when I have to say, you know, I think we need a guardianship, there's a lot of times I'll come home and think to myself, you know, was that just a good day or a bad day? You know, I have those thoughts a lot. There's no real firm, like, what exactly would you 100% have to present to prove you had the capacity to draft a power of attorney? There's nothing out there right now in Washington, interestingly. For a will, yes. For a power of attorney, no. Yeah.
There's a comment that says that this is exactly our situation. So the last thing I described.
Yeah.
That they have a power of attorney, but it's not accepted.
Yeah. And in this situation, it depends. Sometimes it's the power of attorney, sometimes it's them. I do tell client, if it's a slam dunk, if they're clearly wrong, that's when I get to write a nasty gram, you know, that, as we call them, you know, nasty grams, the nasty letters to Chase or Wells Fargo or B of A. But if it's a close call and they're going to fight you tooth and nail, I a lot of times I end up telling clients, at the end of the day, you're going to have a real headache and you're never going to get an apology.
Here's a comment. I was surprised to find out that I was secondary as power of attorney when my brother died. Shouldn't I have been told that I was on the document?
You have no obligation to let people know. You should. But yeah, I could. Lynn, for all you know, you're my backup power of attorney.
Well, that is another situation that I actually have run into in the hospital.
Really?
When we have people in critical condition in the intensive care unit, unable to speak at all, and you find a power of attorney, and when you contact them, they had no idea I was their power of attorney.
Yeah.
Yeah. Awkward. Another comment. Thanks for the information. We appreciate your straightforward approach and your transparency.
A, you're welcome. And B, on that last point, Lynn, yes, thank you. On that last point, you are never obligated to serve as someone's attorney, in fact. If someone nominates you to serve as power of attorney and you didn't know it, you can just write a letter saying, I decline. No one, you don't have to do anything.
And here is another question. Do you need a backup power of attorney?
Need, no. Want, probably.
I've been told that you can't contest a trust. It doesn't sound like that's true.
Oh, you can contest it all you want. Again, contesting and winning a contest are two different things.
And so what's the likelihood if for whatever reason you contest a trust?
Oh, you know, it depends. That's a conversation for another time, and that's also a conversation for an attorney who handles adversarial litigation.
All right, I do believe that that is all of our questions, unless somebody has something else. This is your last opportunity.
And Lynn, I can send you this final updated frequently asked questions so you can send it along to everyone who was on the Zoom.
And I will send it along to everyone. Thank you so much. When you update it, would you comment on the pulse? I think that's important.
Yes, thank you.
I like your response on that.
Okay. I put my phone on airplane mode, but let me make a note of that because I keep my notes in all sorts of different places.
And then for all of you who are here, just to let you know, I will be sending out what he has provided, the Q&A, so that if you need to go back and look, you can. Thank you, Joshua, so much. We so appreciate you doing this for us.
My pleasure, Lynn. Bye, everyone.
Thank you all.